good bond. Court, see lawyer. Don't even stop and get gas in Fulton County. 15 on count 1, 15 on count 2. $30,000 good bond. $60,000 good bond. This year for court, see lawyer. Don't even stop and get gas in Fulton County. $350,000 good bond.
So you got locked up in Fulton County. What's the first thing you're going to do? Cross your fingers and hope you get Judge Manning. And then they're probably going to give you a pamphlet that's going to tell you all about your first appearance, and you're going to look at it and it's going to say you have the right to remain silent, and you're going to say, should I remain silent, or should I keep talking when my lawyer tells me to shut up so that I end up getting like twice as many charges as I should have gotten? Depends on how smart you are. So the first appearance hearing is not the hearing to determine whether the accused is guilty or innocent. So all that explaining to the judge about, what happened and what really, really happened, but what had happened is not going to do you any good, because the only thing they're there to do is to set a date and to issue a bond for your first appearance if you're eligible for a bond. So the presiding judge, as it says here, the presiding judge will inform the accused person whether they are charged with an offense, making sure they understand that offense. And in the case where they won't acknowledge that they understand that offense, like Bearcat Shammy, is that his name? Then they can't proceed. And then setting bond. So what are the bond considerations? The official code of Georgia, which is pretty similar to most other states, but Georgia specifically, because that's where Fulton County is. Fulton County is Atlanta, for those of you who don't know. It outlines the 4 factors to consider to determine whether a defendant qualifies for a bond or not. So the court is authorized to release a person on bail if that person poses no significant risk of fleeing from the jurisdiction of the court or failing to appear in court when required, which is why many of them ask, is there someone who can guarantee your appearance here? Poses no significant threat or danger to any person, to the community, or to any property in the community, which is why you can't get gas in Fulton County. Poses no significant risk of committing a felony pending trial, and poses no significant risk of intimidating witnesses or otherwise obstructing the administration of justice. So the judge also takes into consideration the ties that the person has to the community. Do they have family in the area? What's going on? Do they have a job? If they don't, then they need to stay out of Fulton County. So here's the basics. The hearing's supposed to occur 24 to 72 hours after the arrest, not 367 days, which we'll talk about later. There's 2 types of bonds. There's a signature bond. This is called the own recognizance bond. So there's a lot of different things that it's called in different jurisdictions. Some call it a PR bond, which is personal responsibility, I believe. I'll have to look that up. I can't remember exactly what it is. But released on your own recognizance pretty much means, okay, I accept responsibility. I'll show up. I promise I'll show up. I'm a good person. I'll show up. You don't have to take my money and hold it to make me show up. Good bond, as it's known in Fulton County, which I have not heard that term used anywhere else other than Fulton County, commonly referred to as a surety bond, which is just a normal bond. This bond requires payment of the full bond by the defendant, a private party, on behalf of the defendant or a bail bondsman in order to be released before the next court date. So, a good bond's just a bond. That's it. Nothing about it. It just sounds really good to say good bond. It makes you feel like it's good. It's happy. Hey, you're good. You got a bond. Just stay out of Fulton County. So just a few things to go through the rules and procedures just because we're here. And, it's kind of good to understand the process because we don't always understand the process. So the defendant's brought into the courtroom or the Zoom meeting, sometimes, if they can figure out how to turn the camera on. And they're explained their rights and what to expect during the hearing and what factors the judge will consider in determining whether to set bond or at what amount. So the judge is receiving information in real time on each case, as it's called from sources, pretrial services, probation officers, the prosecutor, and the attorney for the defendant can give them information, tell them what's going on, what the history of the person is, what the facts of the case are, so that the judge can make an informed decision. The accused has to state his or her name when called by the judge and remain silent until the matter is concluded. That should be bolded and in like a 72-point font. So, the judge advises the accused person of the charges against them. They review the warrant to ensure that probable cause exists for the defendant to be there. Then the judge hears the history of the accused person. The attorney provides a statement and asks the court for a bond, and the prosecutor gives their recommendation. And based on all that information, the judge makes their determination on whether they get a bond or not and what guidelines they have to follow on that bond. So those guidelines are up to the judge. So when the judge is issuing the orders, many judges will add in things that are specific to that case. For example, when you steal from the Family Dollar, the judge will say, hey, you can't go back to any Family Dollar stores. Which, you know, if you need something from a Family Dollar, you're screwed. Also, Chick-fil-A. Don't go to Chick-fil-A. Don't get gas. There's all kinds of considerations that judges can add in there, and based on the rules, it is up to the judge on what to add. So how do we know that it is up to the judge to decide what the rules are and the conditions of the bond? Because the Uniform Rules of the Magistrate Court says so. So this is a 115-page document that is printed in a very large font in a landscape format that goes through all the rules of the court and tells them exactly what they can do and how they handle everything. And so when you go through here to the bond section, okay, Rule 23 of the Uniform Rules of the Magistrate Court is bail in criminal cases, and 23.1, misdemeanors, 23.2 is felonies, and this is what gives judges the right to set bail for offenders, or potential offenders, because you're innocent until proven guilty. And those statutes, 17-6.1 and 17-10.1, provide who should hear the bail determination, whether it should be the magistrate for lesser offenses or it should go up to the superior court for more severe offenses. And then it also outlines the categories of bail, whether it's going to be cash, you have to pay the full amount, you can go to a bondsman, or you're released on your own recognizance. So this is a fun little document. It has a little question and answer session, like, what do you say if you're asked this? It's pretty cool. You need one of those for life. But how do I get a friend out of jail? So if the bond is set, advise the party to contact law enforcement concerning a bond. When will I get my bond money back? Bonds are only released upon the order by the judge or final resolution of the charges. That means if you bail somebody out of jail today and their case gets drug out for 3, 4, 5 years, because it does happen sometimes, your money is tied up until that point. So remember that when you get that call from your friend that you got gas in Fulton County and got locked up. And that is the deal with good bonds.